Okay, I think it's time to discuss the issue of interpretation of Article 3 National Treatment Obligation Clause of WTO agreement. Uh, let's take a quite easy hypothetical example of trade here. Uh, let's say this country is imposing 2,000% of tax on doggy sale, whereas only 10% tax on pony sale. Does it look like a pony? But anyway, any imported dog as well as domestically grown dog must be paying their tax on of the 2,000% whenever it is sold in the market, whereas only 10% will be charged on pony trade. So, does anybody find any problem with this kind of situation? If we talk about international trade issue, right, then probably let's talk about domestic politics issue first, because I'm really growing dog, and my neighborhood is growing pony, and we are really close friends. So whenever I sell my product, which is doggy, right, then I have to pay 2,000% of tax, and my neighbor just pay 10% tax. That's really unfair. So probably in domestic society, the issue of so-called inequality might cause a lot of problem, a lot of political problem, probably not legal problem, but political problem. When we are engaging in pretty much primary poultry growing industry, why should I pay more burden of tax compared to my neighbor? But when it comes to international trade, such issue of inequality is of no concern at all. You know, international trade law focus on only issue of non-discrimination, non-discrimination. As long as sovereign countries engage in their trade on a non-discriminatory basis, they do not impose any discriminatory measures, then there's no problem from the point of the view of WTO system, because it's international trading system. So as long as doggy and pony are not like product, they do not compete against each other in the market. No matter how high tax you charge on doggy trade, that does not affect the price of pony. So such you know uh, very big difference of tax is not causing any problem in the WTO system. So what triggers the violation of international trade law provision, which non-discriminatory provision, is the case where two products at in comparison are like product or directly competitive product at least, and one of the WTO member country charges quite different rate of tax or tariff and trade measures. Because of that, the product subject to lower trade barrier has more competitive advantage in the market, whereas other like product or directly competitive product who is subject to higher burden will have less competitiveness in the market. That kind of situation is called discriminatory treatment, and that issue of discrimination is the kind of issue that will be controlled by the WTO norm, which is Article 3 of GATT. national treatment obligation. So in a sense, WTO law as a treaty just care about discriminatory rule, and all the rest of the issues, such as inequality, is simply given to each WTO member countries' discretion. So how to solve their domestic inequality is totally up to sovereign jurisdiction, where international law does not intervene. So probably one may say there is kind of division of labor between domestic law and international law. Uh, I mean, when it comes to discriminatory rule at issue, then only international treaty law step in to uh, have some stake with regard to that issue. Okay, with that basic understanding, so in the international trade law, the definition of discrimination is to treat like product, like services, or like intellectual property right holders differently. That's discrimination. When a government treats different product, different services, different intellectual property holders differently, that's merely differentiation. That's not discrimination. So what triggers violation of Article 3 of GATT is the situation of discrimination, not differentiation. Uh, that's, I think, an important point that everyone should have in mind. So when we read the entire text of Article 3 of GATT, although it's quite long article, so I only show you first 4 paragraphs of Article 3, which are major paragraphs on the Article 3. GATT Article 3 is central provision regulating the application of domestic policies to imported product, which requires WTO members to accord national treatment to imported product. So the broad and fundamental purpose of Article 3 is to avoid protectionism. You know, treating like product differently and creating competitive advantage for domestic like product, which is competing against the imported product, right? That is kind of exercising the protectionism to the benefit of domestic product, right? So Article 3 is to avoid protectionism in the application of internal tax and regulatory measures. More specifically, the purpose of Article 3 is to ensure that internal measures are not applied to imported or domestic product so as to afford protection to domestic production, which is exactly reflected in Article 3, Paragraph 1. As you can see from Paragraph 1, it is really a declaration that Article 3 is really applied to imported or domestic product so as to afford protection to domestic production. So it guarantees that any internal measure does not afford protection to domestic production. So paragraph 1 is kind of a provision that gives general guidance about the very purpose or object of the Article 3 obligation. Is paragraph 1 setting forth legally binding obligation or not? Can a member of WTO argue that you took certain measures, so your measure really afford protection to domestic production. So you are in violation of Article 3.1. Can you make such argument? Because Article 3.1 is legally binding obligation or not? Most likely, answer is not, right? Because if you take a look at the language of Article 3.1, the main verb is recognize, right? Recognize. And here you see the another verb, which is should not, right? So you can see that there's no shall, the word shall here, so it does not set forth absolute obligation uh, to the WTO member country. Rather, it is announcing that the basic principle of Article 3 is that the measure should not be applied to imported domestic products, so as to offer protection to domestic industry, domestic production. So this provision does not have separate binding force, unlike other provisions, right? But it definitely gives a very strong hint what is the very principle or objective of Article 3 as a whole. So whenever you try to find out basic purpose of this provision, I think you have to always make reference to paragraph 1 here. But that does not mean that a member country of WTO can violate paragraph 1 because it's not binding, non-binding provision. To this end, Article 3 obliges WTO members to provide no less favorable competitive conditions for imported product than for domestic product. So the intention of drafters of GATT was clearly to treat the imported product at least equally favorably as the like domestic product once they had been cleared through customs. You see the exact language of like product here in second paragraph as well as in paragraph 4, right? So we can see that Article 3 is caring about discrimination only, not differentiation situation. So whenever two products in comparison are like product, then certain obligation under Article 3 applies. So these provisions do not apply to the relationship between the pony and doggy, because that's not discrimination but differentiation. Okay, anyway. And if you pay attention to paragraph 4 here, Article 3.4 of GATT reads in part, the product imported shall be accorded treatment no less favorable than that accorded to like product of national origin in respect of all laws, regulations, and requirements. So the subject measure that is subject to this paragraph 4 is quite broad, right? Any trade measure in the form of law, even law, which is abstract rule, right? And regulations that implement law, or requirement. Requirement could be easily the administrative measure and not the law. But anyway, any law, regulation, and requirement may be subject to Article 3.4 regulation. Right? It covers really broad area of trade measure affecting their internal sale, offering for sale, purchase, transportation, distribution, or use. So let's say here is you, okay, you, and here's the product that you ordered through the internet, e-commerce. Let's say it's perfume. You order perfume through internet, which is produced in France, and your perfume just arrived at the Singaporean seaport, right? And they will download the product to the to customs office of Singapore, right? Then customs office of Singapore will charge a certain amount of tariff, but luckily Singapore do not charge any tariff on most of the product, right? So it will be tariff-free entry. But anyway, customs will clear this product through the customs area, right? Then as soon as this product is cleared through, right, it will be put into the stage of uh, offering for sale, right? Offering for sale. It will be transported, right? Or it will be distributed, right, to the resale stores, and it will be put into a status of purchasing and use by you. So in each and every stage of this subsequent transaction, after this product is cleared through from the customs check, so in all these stages, this Article 3.4 obligation applies, because uh, when Singaporean certain law or regulation or requirement affect any of these transaction stages, right, then Article 3.4 applies, right? So as you can see here, again, national treatment obligation is really comprehensive obligation that covers pretty broad internal transaction stages. It's a very broad one. And the subject matter that of dispute is if the subject matter of dispute is treatment no less favorable, then there will be violation of Article 3.4, or if there is less favorable treatment, right, between like product, of course. So the general provision that really governs the entire national treatment obligation of WTO when it comes to trading goods is Article 3.4, because it covers broad subject matter, including any law, regulation, and requirement. Uh, Whereas, if you take a look at the second paragraph here, the subject measure indicated on the second paragraph is internal taxes, right here, internal taxes or other internal charges. So you can understand that second paragraph is only covering certain taxes or internal charges, right? So charge usually mean some measure having uh, fiscal or financial nature, right? So only certain measure in the form of taxes or other equivalent fiscal or financial measure will be covered by second paragraph. So whereas the paragraph 4 is general provision covering any internal measure second paragraph is covering only subset of such broad internal measure, which is taxes or other fiscal or financial charges. So we can understand that paragraph 4 is general law that's covering general subject matter, whereas second paragraph is special law that is pinpointing one category of internal measure, which is fiscal or financial measure. So uh, special law prevails over the general law when it comes to the subject matter of the special, nature, right? So when it comes to the issue of discrimination against the imported product with the trade measure of fiscal or financial measure, then second paragraph as special law applies, prevailing over paragraph 4. So we have to pay primary attention to second paragraph and try to find out whether there's a violation or not on the second paragraph itself. That's your first step of inquiry, legal inquiry. But whereas when the issue is whether a certain non-fiscal or financial measure, but internal measure, right, such as law or regulation requirement, which has no characteristic of financial or fiscal nature, then you can apply the paragraph 4 upfront. So you can say that you have certain division of labor of application between second and paragraph 4. Fiscal measure, financial measure will belong to second paragraph jurisprudence, whereas all the non-fiscal internal measures will be subject to paragraph 4. The reason why it's really important to distinguish is paragraph 2 scope and the scope subjecting to paragraph 4 is because two paragraphs have quite delicately different rules or conditions, as we can see from now on. Under the second paragraph, we have two sentences, right? The first sentence is talking about like product here, right? Whereas second sentence, which reads, moreover, no contracting party shall otherwise apply internal taxes or other internal charges to imported or domestic product in a manner contrary to principles set forth in paragraph 1, right? And there is a asterisk at the end of this sentence, right? This means that there is interpretive note that interpret this particular sentence at the back of this treaty. So if you go back last part of GATT, then you will find add article 3 paragraph 2. This is kind of interpretive note that interpret the second sentence, second paragraph of article 3. So this add article 3 paragraph 2 interpret this second sentence, right, and goes a text conforming to the requirement of the first sentence of paragraph 2 would be considered to be inconsistent with the provisions of second sentence only in cases where competition was involved between the text product and a directly competitive substitute product which was not similarly taxed. So here in the second sentence, as combined by interpretive note, right, you see a quite different word, which is a directly competitive substitute product, right, from the words like domestic product, right? So if the situation is a comparison of treatment between treatment on the imported product, right, and treatment on domestic product, right, if those products are like product, right? And the subject matter at issue is fiscal measure, right? Like tax. The second paragraph applies, right? And the product relationship in comparison, like product, like product, then the first sentence, second paragraph applies because it really regulate the like domestic product situation, right? Whereas the subject matter is fiscal measure and product relationship that is allegedly discriminated against the imported product, right? Is not like product but directly competitive or substitute product, right? Then first sentence cannot apply because it is only talking about like product relationship, right? In such case, second sentence of second paragraph will apply. So uh, on top of that, very interestingly, the second sentence of second paragraph is making a explicit reference to the principles set forth in paragraph 1, right? Paragraph 1. Whereas such reference is missing in first paragraph here, as well as paragraph 4 here. Sorry, such reference is missing in the first sentence of second paragraph and paragraph 4. So what does that mean? What does that mean? According to appellate body interpretation in Japan High Court and many other subsequent panel appellate body decisions, since this reference exists only at the second sentence of second paragraph, right? Then that means that this first paragraph principle is incorporated into the second sentence of second paragraph as a condition to violate second sentence obligation. The second sentence itself is incorporating the first paragraph principle into itself, and we see the word shall finally here, right? So now the principle on the first paragraph is not only principle on the first paragraph itself, but it becomes legally binding condition as incorporated into a second sentence of second paragraph. Whereas there's no such reference under the first sentence of second paragraph. Right? So you cannot really say that first paragraph principle will become a condition on the first sentence of second paragraph. That's big difference, right? So in summary, paragraph 1 of Article 3 is not legally binding obligation, but some announcement of general principle as an independent paragraph. But when it comes to the issue of second paragraph, second sentence, right? That principle becomes one of the conditions to satisfy in order to find the violation of the second sentence, right here. Whereas such separate condition cannot be imposed on the first sentence or paragraph 4. So the conditions or element to violate first sentence of second paragraph goes that when one domestic product and imported product in comparison are like product, right? Like product, and tax imposed on the imported product is in excess of the tax rate applied to domestic product, then there will be violation of first sentence of second paragraph. It's very much simple. Two products are like product, and imported product is subject to excessive taxation compared to the tax rate on domestic product, right? So there's only two elements, right? Like product and excessive taxation. Then there will be a violation of first sentence. On the contrary, in order to find the violation of second sentence of second paragraph, right? And the two product in comparison should be directly competitive or substitute product, right? Which is pretty much broader scope of product comparison, right? Like product means really very closely resembling product, right? Whereas directly competitive substitute product could be more than closely resembling product, as long as two products are directly competitive in the market, right? Even though two product are having quite not similar characteristics, still one can say that those are really directly competitive product or substitute product in the market. So like product is really very much close relationship, whereas directly competitive or substitute product is much broader product relationship. Of course, directly competitive or substitute product may include like product relationship, not vice versa, but one may include the other product scope. Uh, and uh, Tax rate imposed on imported product is not similar to the tax rate imposed on domestic product, right? And such dissimilar taxation is applied so as to afford protection to domestic production. Then you can find the violation of Article 3.2 second sentence. So three requirements must be met to find violation. That's pretty big difference between first sentence and second sentence, right? And paragraph 4, again, like product relationship must be found, and treatment given to imported product is less favorable than the treatment given to domestic product. Then you can find the violation. So whether certain issue belong to which paragraph and which sentence is pretty much important because different sentences and different paragraphs have different requirement. So it's pretty much the important point I think you have to have in mind. So as a lawyer, you have to have entire skeleton of jurisprudence of Article 3 of GATT. When the subject measure at issue is fiscal measure, such as tax, right? Then second paragraph applies. In all the other internal measure cases, the paragraph 4 will apply, right? And on the second paragraph, we have two sentences, right? And product relationship is like product, then first sentence applies, and the product relationship is directly competitive or substitute product, then second sentence will apply. Whether the principle stated on the first paragraph applies as an independent requirement or simply guiding principle depends on whether each paragraph or sentence makes a explicit reference to the first paragraph one, right? Okay. Okay, but that's not the end of your legal inquiry, of course, because we have Article 20 general exception clause. Uh, this provision is called general exception because it can give any justificatory ground for the violation of any provision under the GATT. So that's why it is called general exception clause. Uh, if you take a look at subparagraphs here, right? Certain measure necessary to protect public morale and the measure necessary to protect human, animal, plant life or health. Uh, some measure imposed for the protection of national treasure of artistic, history, or archaeological value, right? And measure relating to conservation of exhaustive natural resources. And such enumerated measures can be justified of each violation of any provision of the GATT, including of course Article 3 of GATT, right? As long as those measures are not applied in a manner which would constitute a means of arbitrary or unjustifiable discrimination between countries where the same conditions prevail, or a disguised restriction on international trade, then such measures can be justified of each violation. So, uh, although you find the violation of Article 3, any paragraph or sentence, right? Still, you have to examine further whether such discriminatory measure is one of those subparagraph measures under Article 20, and whether such measures are applied in a arbitrary or unjustifiable manner or not. So that's really end of your inquiry, right? Even though taxation is giving a lot of discrimination against imported product, still, if such discriminatory tax is really necessary to protect human, animal, plant life, or health, right? Some environmental tax, right? Even though it's discriminatory tax, still, if imported product create more pollution in your society, so that's why you charge higher tax on imported product, whereas you charge lower tax on like domestic product. Somehow, imported product create more pollution because of their uh, particular manufacturing uh, facilities or their resources. Then you may charge higher tax on imported product. That's what Article 20 is. Uh, okay. Then the next, issue of interpretation of treaty term is what is like product, right? Like product. Pony and doggy are definitely not like product. It's really easy to, you know, distinguish one product from the other, right? Because they are not like product at all. But answer in many cases is not as easy as that, you know. What about apple and oranges? Are they like product? What about bottled water and non-bottled water? Are they like product? What about uh, squashed orange and just oranges? Are they like product? Orange juice. What about orange juice and orange? What about big car and medium-sized car? Of course, one may say very tiny car and pretty much luxurious big car are not like product. But what about mid-sized cars? There are many, different scale of cars, right? So in such very much different scales, which segment of car are like product to each other, which are not like product. That's not easy to answer. But anyway, one may one should answer that, right? Because in order for WTO agreement to apply, then only like product or directly competitive or substitute product relationship exists, then we can apply Article 3 of GATT. Otherwise, there is really uh, freedom of regulation on the part of sovereign country of the world. So whether like product or not, that kind of determination is really critical element we have to prove. Uh, uh, in Japan alcoholic beverage case, appellate body said like product is really an issue having an unavoidable element of individual discretionary judgment. So the concept of like product seems like a relative one that evokes the image of an accordion. You can play the accordion by stretching and squeezing in different notes. So accordion likeness stretches and squeezes in different places as different provisions of WTO agreement are applied. So simply put, everybody is saying that we don't know what is the definition of like product, but bring the case to us, then we'll tell you whether two products in comparison are like product or not. Anyway, with that general announcement, the appellate body and panel as well ruled that Japanese soju and vodka are like product, right? And Japan applied a different rate of tax on soju and on vodka, and tax rate on vodka was higher than the tax rate on soju, so it was excessive taxation. And since the product relationship like product, then Article 3 and second sentence, second paragraph and fourth sentence applies. So since two requirements are met, so there is a violation of Article 3.2 first sentence. Although Japan argued that paragraph 1, right? Paragraph 1 of Article 3 is really overarching provision that announces the general principle of national treatment. So we have to still apply that provision to the present case and see whether such excessive taxation is to afford protection for domestic production or not. Uh, the to Japanese government, we do not intend to afford protection for domestic soju industry. Uh, Historically we have been imposing such different taxation, so we did not really particularly intended to protect domestic industry. So we cannot violate Article 3.2.1, but appellate body rejected that argument, right? So since first sentence of second paragraph does not make an express reference to first paragraph, we cannot apply the first paragraph as a separate condition to find violation of the second paragraph first sentence. On the other hand, soju on one hand, and on the other hand, whiskey, brandy, rum, gin, and Geneva liqueurs are directly competitive or substitute product. And tax rate is not similar. And since the tax rate between two products is so huge difference, so from that big difference of tax rate, we can easily see that the taxation was applied so as to afford protection for domestic production. Uh, so, according to the appellate body ruling, I don't think they paid heavy weight to the some subjective element of purpose of taxation when they interpret the paragraph 1 of Article 3. Uh, the language so as to afford protection is not really a subjective element or subjective test according to Apple, by the way. Uh, whether Japan really intended to afford protection or not, whether Japan really aimed such protectionist taxation or not, is not really criteria to interpret the paragraph 1 according to appellate body, right? If there's a big tax differentiation tax rate, then that difference itself is giving you very strong signal that tax was imposed so as to afford protection. So general structure of taxation system is what we have to take a look at to interpret Article 3.1, not genuine intention or real aim of the government who took such a measure. So appellate body is really is not uh, pursuing a really teleological approach, Article 3. They interpret much more uh, ordinary meaning style of interpretation of Article 3, and so as to afford protection. The language uh, does not always mean that in order to apply protection, right? So as to could be different from in order to. When you use the word in order to, that clearly means that you intended or but here so as to expression could not have a close linkage with the meaning of intention or purpose. So if the general structure of tax scheme is quite drastically different, then you can say there's a application tax measure so as to afford protection. I think everybody they do not really try to interpret Article 3 relying upon any claim based on the object and purpose Article 3 in general. Uh, in that sense, here everybody's approach is much more textual interpretive approach, whereas Japanese and United States claim based on teleological approach. However, this is really big. However, if one carefully think about the reason why appellate body is interpreting Article 3 in such a way, one may reach totally opposite conclusion. Why does appellate body do this? Uh, appellate body is, in fact, is taking very strong position to make a sort of pro-trade drive, and its interpretation of Article 3 is at the center of this kind of drive. Uh, Everybody, as I summarize, interpret the concept of directly competitive substitute product as broadly as possible, right? Soju and rum, gin, Geneva, or whiskey, all are, directly competitive or substitute product. Such really broad category of directly competitive substitute product. Uh, why? Appellate interpret the term, uh, directly competitive product as such because according to appellate, those products are really sharing pretty much alcoholic content, and at least they are partially competitive in Japanese market, even though they are not currently competing against each other in direct manner, but potentially many Japanese people are mixing liquors together and they drink. So that proves that they are potentially competitive. So even though it's not competitive yet, but it could be competitive in the future. So that kind of potential element as well as future competitiveness are also relevant in interpreting world competitive, directly competitive or subset product. And also, Balabari interpret the term not similarly text on the second sentence of second paragraph of Article 3, probably only in a quantitative sense. If the difference of tax rate between tax rate on imported product and domestic product is more than de minimis level, right? So there is substantial difference, then that is really not taxing similarly. So difference of quantitative difference, right? That is really criteria to know whether there is similar taxation or not similar taxation. And appellate body interpreted the condition so as to afford protection, also in a quantitative sense. So if there is really substantial difference on treatment between imported product and domestic product, then that difference, substantial difference per se, is really affording protection to domestic industry. We don't need to take a look at the intention or particular circumstances of that different taxation, but the structure, general structure of architecture of that difference itself is enough to prove that there was application of uh, taxation so as to afford protection of domestic industry. So it's really a quantitative interpretation of the term. So with this kind of three positions as combined, then it will be very, very effective to catch as many allegedly discriminatory measures as possible. Even those measures that create merely incidental discriminatory effect. So government did not really intend to create such effect, but as a result of such measure, incidentally, such a discriminatory effect might have been caused. Then, only taking a look at that effect of discrimination, appellate body will rule that there was substantial difference of taxation rate and it was imposed so as to offer protection. So there is a violation of Article 3. So in other words, appellate body is endeavoring to interpret many obscure terms or general terms under Article 3 in a very, very coherent manner so that such interpretation may help to prohibit of protectionism, the very object and purpose of Article 3. So what I'm saying is that in this sense, the body is taking extremely strong teleological interpretation of Article 3 here. This upper body interpretation in Japan case is probably the strongest example of teleological interpretation of treaty terms among any interpretations made so far by international tribunals. And probably it's the most cleverest example because appellate body position looks textual approach apparently rejecting any argument based on intention or purpose, but in fact the body itself had its own hidden agenda based on its own interpretation of purpose of the provision and its own strong intention to use the Article 3 tool to strike down as many allegedly discriminatory measures in the world. In that sense, probably one may study this case further and try to learn how the teleological interpretation of treaty is really could play a role in making quite trade law jurisprudence in early stage of establishment of WTO system. When appellate body and panel as well ruled that product in comparison like product or directly comparable substitute product, right? Appellate body and panel relied upon basically three criteria, uh, including physical properties of product, tariff classification, and end use. So here is soju and vodka. Uh, how are their physical properties? It's really alcoholic content material, right? And white liquor, pretty much similar color, and alcoholic content, I mean alcoholic strength is pretty much similar. Then they are sharing really physical, same similar physical properties. Then they take a look at tariff classification. So how does the uh, many countries tariff nomenclature classify two products? Do they classify two products in pretty much similar tariff line or in dissimilar tariff line? So two products are pretty much sharing a similar tariff line. And the appellate body took a look at the end use. Why do you drink vodka? Why do you drink soju? Because to relax, to be drunk, to make friends. So end use of such a product are pretty much similar. So basically, by looking at those three criteria, and if there's sufficient degree of similarity, then appellate body ruled that those two products in comparison are like product. So these three criteria become pretty much standard criteria to determine product likeness since this decision, and it pretty much coherent criteria that was used by WTO tribunal. Okay. This slide shows how much weight of ruling and decision was made on pretty much objective element of comparison, such as design, architecture, and revealing structure of the measure, and quantitative test of difference, right? If there's more than de minimis level of difference, that's dissimilar taxation. So it looks like appellate body is taking quite objective element of interpretation of treaty language, but in fact, because of it had its own agenda and intention to catch as many allegedly discriminatory measure by interpreting Article 3 as broadly as possible, right? So this ruling by appellate body, in fact, shows very much extreme example of teleological approach of Article 3. That's what I've said so far. On the other hand, different interpretation of the term like product based on another strong teleological approach of interpretation of treaty was suggested in 1992, and such approach of interpreting treaty term has been named as the aim and effect approach. Those people who support this approach put forward with very interesting sort of maxim, and according to that maxim, a fox and an eagle are like animals to a hare, but not to a furrier. So what it means basically is that even though it's exactly the same object like fox and eagle, right? That's pretty much the same object. Uh, but it could be seen as like animals to one uh, object, like a hare, right? But exactly same subject, two subject could be seen as totally different material or living being to different uh, object like a furry. Right? So if your aim is to survive, right, like a hare, your aim is to survive, then fox and eagle are like animals. Whether you are killed by fox or by an eagle does not make any difference. Probably being killed by eagle would be more painful. I don't know, but anyway, you'll be killed, right? If your aim is to survive, then two subjects are really like product. But if you have different aim, like aim of earning money, right, and doing your living by selling the product you acquired from the nature, then exactly the same two object like a fox and eagle could be seen as totally different animal because fox fur is more expensive than eagle's feather, definitely. So without taking into consideration of which aim you have in the first place, how can you make a conclusion that two objects are like product or not? So the concept of like product inherently include a perspective of the certain entity who was taking a certain measure against such object. That's what this aim and effect theory people are arguing. So by applying this kind of new paradigm or way of thought, the United States Malt Beverage panel in 1992 and U.S. Automobile panel in 1994 made a quite interesting ruling regarding the like product issue. In 1992, United States government charged quite different rate of tax on uh, more higher rate of tax on strong beers, which are mostly imported from European countries, and lower rate of tax on domestically produced beers. You know, Belgian beer are stronger than American beers, right? The reason why United States government did at the time was to uh, protect minors' health, according to U.S. government explanation, because minors usually do not have money. So if government charges higher tax on imported strong beers, the price will become much more higher than domestically produced light beers. Right? So minors tend to purchase light beers instead of stronger beers. So that way you can protect minors' health. In 1994, U.S. government charged higher rate of tax on large size automobiles and lower rate of tax on medium and small size automobiles. The reason, allegedly, is because large size cars are emitting more pollution, right? Pollution gas. So it really damages the environment. So they want to protect the environment. That's why they charge us higher rate of tax on mostly imported large size cars. In those days, European countries exported more large size cars compared to the local cars in the United States. So uh, whether stronger beers and light beers are light product or not, that is the major issue in case A. Whether large size cars and medium size and small size cars are light product or not, that was that issue. because subject measure at issue was taxation. So Article 3.2, first sentence could apply when it comes to like product relationship, right? And according to the panels, the aim of the United States government was to protect minors' health and protect the environment. So from that aim, seen from that perspective or aim, light beers and stronger beers are not like product, and large size cars and medium size cars are not like product. So they ruled that there was no violation of Article 3 of that. It's as simple as that. Because there's no like product relationship, then there will be no violation at all, even though there's a difference of tax rate. So this two decisions really turned a new page in like product debate. You have to take a look at the aim of government who took a measure first, and from that aim, you have to take a look the product in comparison and see whether fox and eagle are like product one. And that's the way you should proceed with your like product determination according to this approach. It's quite totally different approach, right, from the current approach of appellate body. Now, current approach is take a look at the product properties, right? Light beers, stronger beers, they are made of pretty much same source material, and alcoholic content not much seriously different, right? Pretty much similar, and tariff classification and end use. Then it's more likely that they will determine two product like product, right? Large size cars and medium size cars, you know, if it's too large and too small, probably not like product on the current approach as well. But that's not that much difference. Then it's more cars within that range might be ruled as like product on the current approach. But on the 1994 panel approach, that's totally different product. So the reason why this aim and effect approach was put forward with was, according to those people who support the approach, is because the basic purpose of Article 3 is not to punish certain measure that create incidental discriminatory effect on trade relationship. So even though it really was included into WTO GATT treaty to prohibit protectionist taxation, but it was not really intended to punish any unintended discrimination. So we have to really be careful in applying Article 3, purpose of Article 3, to distinguish some genuine discrimination and incidental discrimination. That's what those people who support this approach was based on as a starting point. So from that basic purpose of the treaty provision, how do you interpret the term like product? Of course, we have to take into account the aim of entire provision first, whether it really genuine discriminatory intent or not. What is the purpose of the measure taken by government A? If the aim is legitimate, then we have to think from that aim whether two products in comparison are really having genuine discriminatory effect or only incidental discriminatory effect. So proper order to determine the like product is going from the determination of aim first and going to the determination of effect. So that's why they call it aim and effect test. According to them, current appellate approach is only taking a look at the effect on trade, right? No matter whether the country who took the measure has legitimate aim of differentiation, But still, if there's a discriminatory effect, even though that's really incidental effect was created by such measure, that is really discrimination that must be prohibited. That kind of approach is not really what was originally aimed by the drafters of the Article 3 itself. Why don't you take a look at Article 3.1? Uh, First paragraph of Article 3, it's really saying that you should not apply your measure so as to afford protection for domestic industry. That means that genuine protectionism must be condemned under this article. That's the proclamation of such purpose of Article 3. So these people interpret first paragraph of Article 3 in much more uh, you know, quite different from current appellate body approach. They give more weight to the word of so as to afford protection, pretty much similar to in order to afford protection. So any genuine intention of discrimination and protectionism need to be addressed first in order to go on to determination of violation on the following paragraphs on the Article 3. Uh, So uh, basically, we have very much different outcome of determination of likeness if you follow current appellate body position and comparing to the case where we follow aim and effect approach, then there will be quite different outcome of the likeness determination. But what I'm trying to stress here is that the two approaches are really typical example of teleological interpretation of treaty term. Uh, One approach interpret the purpose of Article 3 in quite pro-trade orientation, whereas the other approach, which is aim and effect, interpreted the purpose of the Article 3 in more balanced way. I mean the balance between free trade and protecting legitimate governmental governmental regulatory autonomy. So anyway, the one fact that is clear is that two approaches are really based on their own version of understanding of aim or purpose or object of the treaty term, treaty provision, and based on such understanding, they went on to interpret the treaty terms on Article 3. In that sense, even though their conclusion would be different, but I think they are sharing the same line, same approaches. This observation by myself does not mean that appellate body's interpretation or aim and effect theory school of thought interpretation go against the Vienna Convention rule of treaty interpretation. In the end, the treaty term must be interpreted in accordance with ordinary meaning, but that meaning must be found in context as well as in light of object and purpose of the treaty. So when certain treaty uses a very generic term, such as like product, that is flexible enough to incorporate any approaches, I think in such case it is really inevitable to rely upon what is the really purpose and object of the treaty and try to find out the meaning of such term in such context. So at the end of the day, I think what fulfills the textual approach could only be teleological approach in such circumstances. Anyway, in applying such teleological approach, I think one must be really careful, to find proper limitation that should not be exceeded in application of such purpose-based orientation. So how to find the proper limitation and balance between some ordinary meaning and purpose of the treaty and how to combine those two factors together to come up reasonable interpretation. I think that is really fascinating issue, and it's really not totally settled issue. And how to apply Article 31 and 32 of Vienna Convention uh, is really intriguing topic to anybody who are interested in treaty interpretation. This is the end of this slide, and we will continue our discussion of treaty interpretation next week. See you in class.